testified in this chamber before the Senate, correct?
Yes, I have.
Okay, so you know the acoustics in here can get a bit weird, especially for our folks in the back.
That's correct.
So please just introduce yourself to the jury and tell us about your career.
My name is Austin Kinghorn. I'm the Associate Deputy Attorney General for Legal Counsel at the Office of the Attorney General. Would you like me to go back from the beginning?
Yeah, sure. Why don't, if you could please just start with law school, walk us through what you've done up to the present day.
So I graduated from Baylor Law School in 2010. After that, I did a clerkship on the 14th Court of Appeals for then Justice Jeff Brown. I did a stint in commercial litigation. Yes, sir. I did a stint in commercial litigation after that, primarily doing insurance defense. After that, I went to work for the AG's office in the Civil Medicaid Fraud Division. When Justice Brown was elevated to the Texas Supreme Court, I went to work for him again as a staff attorney. I worked at the court for about 6.5 years in that capacity for Justices Brown and later Justice Jane Bland. And then came back to the AG's office in the General Counsel Division. From there, I was promoted to General Counsel, and then most recently to the title that I hold now.
Thank you, sir. And tell us a little bit about your work for the Attorney General and your current roles, both as General Counsel, Opinions Committee, and your current title.
Right. So as the Associate Deputy for Legal Counsel, I'm over two divisions. It's a General Counsel Division and the Opinion Committee. In that role, I am both the Division Chief of General Counsel and General Counsel for the agency, and also Chair of the Opinion Committee.
How many employees do you oversee?
19.
And are you proud of your time at the Attorney General's office?
I am very proud.
I think this is a bit of a silly question, but it's come up a lot. Are you a rhino? Do you know what a rhino is?
Yes, I do. I've been called a lot of four-letter words. That's not one of them.
What are your politics? Are you conservative?
Yes, I am.
Again, I think it's a silly question, but it's being asked. On a scale of 1 to 10, how conservative do you think you are?
11.
Fair enough. What I'd like to do today with you is go through these articles of impeachment, see if there's any perspective you can provide as to each. And I appreciate you being here helping explain the work of the agency for the jury. So let's start with Article 1, which relates to the Mitty Foundation and the intervention into that lawsuit. Were you directly involved in that lawsuit or that intervention in any way?
I was not.
Okay. But are you familiar with EAMs?
Yes, I am.
Unfortunately, we've talked a lot about EAMs during this trial. What's your understanding? What is an EAM to you?
An executive approval memorandum is a document that the agency relies on to seek and attain executive approval of various agency actions or engagements.
And do you receive EAMs as part of your work?
I do. I probably receive one or more a day.
What do you do if you have concerns about an EAM?
If I have concerns about an EAM, typically the practice is going to be to reach out to who circulated the EAM and, engage with that person directly, try to flesh out the issues. Sometimes it's simply a matter of correcting something in the EAM and recirculating it. So, the first step is always just get in touch with the folks who are asking for the executive action and connect and make sure you have an understanding of what's going on.
If you get an EAM that you're concerned about or you're proposed a course of action that you don't agree with, do you just go ahead and sign the EAM anyway?
No, I do not.
Okay. So what does signing the EAM signify?
That would signify that you have reviewed the EAM, you reviewed the legal authority in it, the explanation of the rationale for the action that's being sought, and that you approve of that action being taken.
So if someone at the Attorney General's office signs an EAM, does that mean they've approved that action?
That's correct.
What about, let me ask you this. Does the Attorney General have to have an EAM that's fully approved by his subordinates before he takes an action?
No, he does not.
Why not?
The Attorney General's authority and the First Assistant's authority flow directly from the Texas Constitution and from statutes, specifically Government Code Chapter 402. The EAM process exists to vet certain proposals, but it is ultimately not binding on the person or persons who actually possess the constitutional executive power to act as Attorney General or on behalf of the Office of the Attorney General.
So just to make that clear, the Attorney General has the legal authority to act without an EAM approved by his subordinates?
Absolutely.
Okay. Does that include the authority to sign a contract?
Yes, it would.
Let's look at an example of an EAM. Can we pull up House Exhibit 62, please, Mr. Arroyo? Your Honor, I believe this has already been admitted into evidence, and I'm going to try and go electronic today, so we'll see if it works. And Mr. Arroyo, if you could just zoom in on the signatures on the top of this EAM and maybe capture the subject line as well. Have you seen this EAM before, Mr. Kinghorn?
Yes, I have.
Okay. And which EAM is this?
This is a EAM requesting approval to intervene in the Mitty Foundation litigation.
You weren't a signatory on this EAM, correct?
No, I was not.
Okay. But let's look at the first signatory. That's Mary Henderson. Who is that?
Mary Henderson at the time was in our financial litigation division, and she held a senior attorney role in that division.
And what does her signature on this EAM indicate?
That would indicate that she has approved of the action described in this EAM, and it looks like she's the one who actually circulated this EAM.
Why do you say she's the one who circulated it?
It says from Mary Henderson, and also she's the first signatory. So typically the first signatory on the document, the lowest signatory would be the person who actually routed the document for approval.
So does this indicate that Mary Henderson and Kat Day actually authored this EAM? Is that what this says to you?
That's likely the case, yeah.
Do you know whether the Attorney General ever spoke with Mary Henderson or Kat Day about this EAM?
I do not know.
Okay. Who's next on the signature line? Who's Josh Godby?
Josh Godby at the time was the division chief for the financial litigation division.
And what does his signature here indicate?
That would also indicate approval of the action that the EAM is seeking.
And who's next up the chain on this EAM?
That's Darren McCarty.
What was his role at this time?
At the time, he was the Deputy Attorney General for Civil Litigation, so you'd see his name a lot on EAMs like this involving requested courses of action in active litigation.
And again, I want to be clear about what his signature means here. When he docu-signed this EAM, what does that indicate to you as General Counsel of the agency?
That indicates approval of the action that is sought by the EAM.
And same question with Mr. Mateer. What was his role and what does his signature here indicate to you?
Jeff Mateer was the first Assistant Attorney General at the time, and his signature would indicate approval of the action that EAM seeks.
And would it be your expectation that all of these people who signed this EAM have read it?
It would. I mean, that is certainly the point.
That's what you normally do within OAG, right?
Correct.
And would it be your expectation that they understood the memorandum before they signed it?
I would not sign an EAM that I did not
Objection,
fully
Your Honor.
understand.
Question calls for speculation.
I'll move on. Thank you, Mr. Roy.
Sustained. And
all right, let's move on to talking about Article 2. That's about the foreclosure guidance letter. It's been called a lot of things in this courtroom. That's what I'm going to call it. Do you understand what I'm referring to? Are you familiar with that letter?
I do understand, and I am familiar with it.
Okay. Did you work on that guidance letter personally?
In a very limited capacity early on, I performed some very perfunctory research on it. I never participated in the drafting of the letter itself.
Who asked you to do that research?
Ryan Vassar.
And did you form a conclusion as to what was the ultimate outcome in your limited role?
As memory serves, I didn't form any firm conclusions at the time. I performed a couple hours, maybe 3 hours of research, and really just had enough time to kind of come up with some general parameters of what the issues were. And Mr. Vassar and I had a phone conversation about what we had found so far in our respective research, and he took it from there, and I never had another conversation with anyone else about the letter moving forward.
Did you see the letter once it was ultimately issued?
Only when it was issued, yeah, when it went up on the website.
Right, so to be clear, you weren't involved in the drafting process, so you don't know how they got from A to Z on that.
That's right.
Okay, but you saw the final letter.
I did.
Did you agree with the analysis and the conclusion in that letter?
I do.
Objection, Your Honor. Relevance.
Overruled.
And just as sitting there, as you sit there today, can you briefly explain what that letter does in your view?
Well,
or rather, let me rephrase. Can you explain the conclusion of the letter?
the legal conclusion?
Yes.
The legal conclusion essentially was that under the circumstances of COVID at the time, with 10-person restrictions on in-person gatherings, that there was a possibility that a public sale, as defined by statute, that necessary element to proceed on a foreclosure wouldn't be satisfied if you didn't have a situation where anyone who wanted to be a bidder on a property that was under foreclosure would have an opportunity to bid on it and thus get the best, most fair value for the property.
Let me make sure I understand each piece of that. So you mentioned the public sale issue. That's a requirement out of statute. Did I understand you?
That's right.
Okay. And you mentioned a bidder being excluded. Why would that be the case?
Sorry, could you repeat that?
I thought you mentioned the 10-person requirement might result in a bidder not being able to participate in a foreclosure sale. Why would that be the case?
Correct. So normally these sales are open to the public. Anyone who wants to go bid on a property can, and that of course has the effect of increasing the price typically. And the COVID restrictions are at the time, the governor's executive orders only permitted 10 people to gather at once in what was considering, I think the nomenclature was at the time, a public gathering.
So to make sure I understand what you're saying, if there were bidders that were excluded, that could drive the price down at the sale?
Yeah, that's certainly a possibility.
Okay. In your view, does that letter shut down foreclosure sales in the state of Texas?
I don't have an opinion on whether it did or didn't. I do know it was non-binding and informal legal guidance.
Did you work on any other COVID-related opinions or guidance documents?
I worked on a great number of them. During my first several months at the agency, starting in June of 2020, COVID-related work was the vast majority of what I was doing. And
if you could just briefly for a minute here, explain to the jury, explain to the public, we're trying to explain the work of the Office of the Attorney General today, so explain what it was like to be working on these issues during COVID.
It was intense. It was a demanding time, as I'm sure it was for a lot of people in this room. We were on the cutting edge of a lot of novel legal issues. A lot of folks were looking to the AG's office for guidance and direction on how to respond, how to navigate the challenges that were coming forward, especially as it pertained to the governor's executive orders, which were coming out. We were often looked to for guidance on how to comply with those, what they meant construing them, and we fielded those requests from all corners.
Was it unusual during that time to have expedited requests or to be working on short deadlines?
That is never unusual at the OAG, under any circumstances.
Particularly so during COVID?
Sure, particularly so. Everyone who came to us with a problem needed an answer and wanted an answer, at least quickly.
Understood. Let's talk about opinions and guidance documents from the Attorney General's office more broadly. What kinds of guidance can the Attorney General issue? Well,
there's a range of options. A lot of folks in this room are probably familiar with our formal legal opinions. Under Chapter 402 of the Government Code, a authorized statutory requester may request a formal legal opinion from the OAG, and that opinion, while non-binding, is a source of persuasive legal authority that courts typically will look to and consider when resolving a case. But we have other tools in our belt beyond that. Additionally, under Chapter...
Before we go to the next one, I just want to clarify one thing. You mentioned that a lot of folks in this room might be familiar with that formal legal opinion. Why would that be the case? Why would these senators and some of these House members be familiar with that?
Chairs of legislative committees, senators and House members, are authorized requesters under the statute.
Okay. Does the Attorney General's office work frequently with those authorized requesters regarding their requests for opinions?
We frequently work with members of the legislature on a host of issues and try to be as solicitous as possible in being helpful and giving the best legal guidance we can.
Okay. And I'm sorry I interrupted you. So that was the formal legal opinion process. You're moving on to the next category, so I apologize for interrupting.
Sure. So under Chapter 418 of the Government Code, which is the Texas Disaster Act, the AG's office has additional authority to provide legal counsel to local political subdivisions during a declared disaster. Authorized requesters include mayors, county judges, county commissioners, emergency management directors. Beyond that, the office has historically operated with the understanding that we have broad legal authority with the Attorney General as the chief legal officer of the state to issue informal guidance of public note, of public interest that would have a wide applicability to the public at large, especially in disaster situations where there's a need to get good information out to the public on pressing issues. And that authority, I think, flows directly from the Attorney General's constitutional and statutory authority as the Attorney General, as the chief legal officer of the state.
Other than the foreclosure guidance letter, can you recall any examples of other COVID-related guidance that was issued that also fell in that third category you described?
We put several guidance documents out on issues that a lot of folks are facing. Churches, private religious schools. I know that we did some opinions on access to vacation homes, and not opinions, letters on access to vacation homes in other states, where golf courses fell in terms of the governor's orders for shutdown purposes. So there were a lot of topics that we put something out there short of a formal opinion that was designed to provide generally applicable informal legal guidance to the public at large.
So it's fair to say, is it fair to say that the foreclosure letter was not unique in that regard? It was not the only informal guidance that was put out?
That's correct.
Let's look at a couple of other examples of guidance from this time. Mr. Arroyo, if you could pull up House Exhibit 105. And I believe this has already been admitted, Your Honor. Are you familiar with this document, Mr. Kinghorn?
Yes, I am.
And just very briefly, what is this document?
Objection, Mr. President. This document is not in evidence.
I apologize. I thought it had been admitted. It's House Manager's Exhibit 105, and I'd offer it if it hasn't been admitted.
We thought it was pre-admitted, Ms. Epley?
No, Mr. President, I don't believe so. We don't object. It's our document to begin with. I just wanted to make sure the record was clear.
Yeah, I apologize. I tried to get this smoothed out with counsel before we started, but yes, I offer it if it hasn't already been admitted.
Okay. It will now be admitted into evidence. That's exhibit, what's the number, 105?
House Exhibit 105, Your Honor.
Okay. Admit it to evidence.
Mr. Kinghorn, if you could, please just, if to the extent that you can, please just describe briefly what this document is.
This was a general guidance document that the agency issued to houses of worship during the COVID pandemic.
Is this a full-blown opinion under Chapter 402?
It is not.
And is this a disaster council letter under Chapter 418?
No, this is not.
Mr. Arroyo, if you could show us the bottom of the page, there's a date next to the exhibit stamp. And when was this letter issued?
It says April 27th of 2020.
Do you think it was any way improper for the agency to issue this guidance?
No, I do not. And in fact, I think this is the kind of guidance a lot of folks were looking to the Attorney General to provide.
Let's look at another example.
May I seek clarification? He was confirming that the guidance in regards to the house of worship Exhibit 105 is not something he takes issue with, correct? Not the foreclosure letter itself?
Your Honor, she can cross-examine the witness.
No, I'm clarifying.
This is my examination, and
Yes,
she shouldn't be able to.
You can cross-examine on that.
Okay, thank you.
Thank you, Your Honor. Let's briefly look at House Exhibit 104 next. I also thought this one had been pre-admitted. Maybe I'm wrong. To the extent that it wasn't, I'd offer House Exhibit 104.
Thumbs up.
Great. Mr. Kinghorn, have you seen this letter? Or rather, are you familiar with this letter?
Yes, generally speaking, yes.
Okay. This is a letter in response to Chairman Frank.
Yes, this is the one about the golf courses. Okay, I had to read a little bit into it.
Okay, great. Let's look at the last page, please, Mr. Arroyo. If you could just zoom in on that text, please. So this letter, was this a full-blown Chapter 402 opinion?
No, it was not.
And how can you tell that?
It's got some language there caveating that it is not a formal opinion issued pursuant to Section 402.042, which is our formal opinion statute.
It says on the letter that it is not a formal opinion under Chapter 402.
That's right.
So if someone were to say that this was a Chapter 402 opinion, they would be wrong. Do you agree?
I do.
Are you aware that the foreclosure guidance letter has substantially similar language in it?
Yes, I am aware of that.
Okay. And who was this letter signed by?
Ryan Vassar.
So Ryan Vassar signed an informal guidance letter.
Yes.
Does that indicate to you whether Mr. Vassar thought he had the authority to sign that letter? Do you think there was an issue with authority for issuing this letter?
I assume that he operated under authority to issue this letter on behalf of the agency.
Did you think a requester was necessary for the foreclosure letter?
No, I did not, personally.
Do you have any personal knowledge as to why one was sought?
I do not.
So you'd have no reason to disagree with me if I were to tell you that a requester was demanded because someone was trying to get out of doing the
Objection,
work.
Mr. President, I'm sorry. Counselors testifying to facts not known to this witness.
Sustain.
You can take that down, Mr. Royal. I think that's enough for Article 2. I think we're going to skip Articles 3 and 4 because I don't think you have any unique responsibility with regard to the PIA. Is that true?
I do not, that's right.
And we've heard plenty about the PIA today. But as an aside, does the Attorney General have the authority to access any case file or file in the agency?
Yes, I believe he does. He's the Attorney General.
Why does that give him the right to access any file he wants?
Well, I guess there's kind of an old saying in the legal profession that his name's on the wall. It's his agency, and he's the duly elected Attorney General. So it's his law firm. He gets to see a file if he wants to see it.
So if someone were to say that the Attorney General improperly accessed a file, would that make sense to you?
That would not compute to me.
Me neither. Can we pull up Article 4 briefly, Mr. Arroyo? Do you see the allegation here where it says Paxton improperly obtained access to information held by his office? Did I read that correctly?
Yes.
Let's go to Article 5 now. Take that down, Mr. Royal. Are you familiar with the contract with Brandon Kamek?
I am.
Okay. Did you have any involvement with hiring him?
I did not.
Did you have any involvement with drafting the contract or executing it or anything like that on the front end?
I did not.
Okay. When did your involvement with this particular contract begin? When did your familiarity with it begin?
Sometime later, after the contract had been terminated, I believe Mr. Kamek reached out to our office to inquire about payment on the contract for the outstanding invoices.
And when you say reached out to our office, does that mean he reached out to you as general counsel, someone in your division? Do you recall?
My best recollection is that it was a phone call to the general counsel division. I think he was looking for someone to talk to about it.
Do you remember a date for that phone call?
I don't.
Was that before or after you'd been promoted to general counsel?
I believe it was after.
Okay. And when were you promoted to general counsel?
During the month of November of 2020.
Okay. So sometime after your promotion in November 2020, Mr. Kamek called to inquire about payment on his contract. Is that your testimony? I just want to make sure I understand the timeline.
That's right.
Okay. You were made aware of this phone call. What did you do with that information?
I conferred with Leslie French, our chief of staff, on that, primarily because she had more awareness of these issues and what had been happening at the time. As I said before, I had no involvement with the contract. So she and I recall discussing it.
Objection, Mr. President. Question calls for hearsay, or he's about to get into hearsay at this point.
And let me clarify. Please don't.
Sustained.
Yeah. Thank you. Of course, I agree. Please don't relay the contents of any conversation that you had with anyone else. Don't tell me what anyone said. Again, I'm just asking, once you became aware of this request for payment, what happened next? So you said you conferred with Leslie French. Please pick up there.
My best recollection on this is that at some point, a call was made to Mr. Kamek.
Objection. Anything he could state after that is going to be hearsay.
We don't know what he's going to state next, so I don't think that's true.
Overruled.
In that case, anything next is non-responsive. May he ask another question?
You can break it down into questions.
Did you reach out to Mr. Kamek?
Yes.
What was the purpose of reaching out to Mr. Kamek?
To follow up on his inquiry.
What did you want Mr. Kamek to know when you followed up with him?
Objection, Your Honor. Hearsay.
I didn't ask for what he said. I asked for what he wanted Mr. Kamek to know in response to his inquiry.
Overruled.
The purpose of the call was to inform Mr. Kamek of how he might proceed about processing his invoices under the contract.
And what were Mr. Kamek's options to get paid at that point?
There remained work within the scope of services that had not been satisfied before we could issue payment. Specifically, the preparation of a report of his findings hadn't been completed. So what I relayed to him, and I believe this was over a voicemail, was that we couldn't make payment on the contract until that commitment had been made.
If Mr. Kamek had sent you that memo that he had contracted to provide, what would you have done?
Subject to any other clerical reason that we might have to shore up, from my view, it was a payable invoice because it was a valid contract at the time that the services were performed.
Did you ever hear back from Mr. Kamek after you advised him that if he sent you the memo, he could get paid?
I did not.
Mr. Kamek never called you?
Not to my knowledge.
And again, when was this, to the best of your recollection?
My best recollection is it would have been sometime in November or later.
go ahead and skip ahead to Article 7, just briefly. Are you aware of the Attorney General's Office internal report regarding the events underlying this impeachment proceeding?
Yes.
And broadly speaking, what is that report as you understand it?
That report is the findings of a 10-month investigation that was conducted internally at the Office of the Attorney General concerning the allegations that the whistleblowers raised.
Did you ever review that report?
I did.
How many times? What was the nature of your review?
2, no more than 3 times. I was provided a copy and asked for general feedback on the document, proposed edits, revisions, things along those lines.
Were you ever directed by anyone to make sure that the report was a sham?
No.
Were you ever directed to make sure it included false or misleading statements?
Absolutely not.
Are you aware of anyone else receiving such a direction?
Absolutely not.
What would you have done if you had identified a false or misleading statement in that report when you reviewed it?
If I had identified a false and misleading statement, I would have immediately raised that issue to the folks who were working on the report for consideration.
When was that report published?
That was August 24th, I believe, of 21.
And just to be clear, I'm looking at the text of Article 7 here. The allegation is Paxton directed employees of his office to conduct a sham investigation. Are you aware of that occurring?
I'm not aware that that occurred.
And you're one of the employees who, at least to some degree, worked on the report?
That's right.
The report was published in August 2021, you said?
That's right.
And it's been on has it been on the Attorney General's office website continuously since that time?
Yes, it has.
So, was that before or after November 8th, 2022, that this report was issued to the public?
After. Can you repeat the question?
Sorry.
I
Was
may
the
have misheard the
report made public before or after the Attorney General's election on November 8th, 2022?
Oh, I'm sorry, before.
Before. It's been on the Attorney General's office website continuously since then.
That's right.
Are you aware of whether there was reporting on the issuance of that report?
There's been extensive reporting on the issues that were discussed in that report.
When did that reporting begin, as far as you're aware?
That reporting began pretty much immediately when the whistleblowers reported General Paxton as law enforcement, and it's something we've been dealing with ever since.
And the OAG report also contains the details of those facts?
It does.
And that's been public?
Yes.
On the Attorney General's website?
Yes.
You can take that down, Mr. Roy. Let's move on to discussing Article 8 a little bit. Article 8 deals with the settlement of the Brickman versus Office of Attorney General litigation. Are you generally aware of that litigation and that settlement?
Yes, I am.
As part of the agreed settlement terms in that case, are there any contingencies that must be satisfied before the settlement is fully effective?
Well, the biggest contingency would be funding for the settlement itself. I think there may have been some non-monetary considerations as well, but I think maybe the one you're asking about is the contingency of the legislature funding the requested amount.
That is the one I'm asking about. Why is that legislative appropriation of funding contingency necessary for this settlement?
Like other state agencies, the Office of the Attorney General is prohibited in the General Appropriations Act from settling a case for more than $250,000. without seeking additional funds to do that.
Does state law set out a process for seeking funding for such a settlement?
It does.
Did the Office of the Attorney General follow that process?
Yes, we did.
Do you know whether funding was appropriated?
It has not been appropriated to the state.
Has the Office of the Attorney General paid out a single dime on this settlement?
It has not.
As far as you're aware, has a single dime of taxpayer money been spent funding that settlement?
It has not.
Who decides whether that will ever happen?
At this point, ultimately, the legislature will.
The House and the Senate?
Correct.
It's up to them whether to fund it.
That's right.
The Attorney General can't force them to do that, can he?
He can only ask.
Let's pull up Texas Government Code section 554.010. Your Honor, this is just a statute. I'm not offering it as an exhibit. It's going to be up on all of the screens. Mr. Arroyo, if you could zoom in on that. And I have paper copies for the witness and the court and opposing counsel, if that would be helpful.
Now this will work.
Are you familiar with this provision in the Whistleblower Act?
Yes, I am.
Can you explain in English what the statute means?
So this is essentially a reporting requirement. There's two parts to this. When you pay out on a settlement or judgment in a Whistleblower Act case, the agency is required to essentially put together a report on that case. And following that report, the state auditor's office may initiate an audit or an investigation of basically what went into what happened with the Whistleblower Act complaint. And if the SAO initiates that investigation, then they must follow up with a report to several entities on improvements that can be made, things that can be changed to prevent this from happening again.
So let's break that down. Let's go piece by piece. If the settlement is consummated, the Attorney General's office has to do what?
It has to put together a brief memorandum describing the facts and the disposition of the suit, and it has to provide that to the state auditor's office.
Okay. The Attorney General's office has to prepare a memorandum describing the lawsuit and send it to the state auditor's office. What happens after that? What does the state auditor's office do with it?
The state auditor's office will review the report, and not later than the 90th day after that report is submitted, the SAO has the option to investigate the governmental entity or conduct an audit.
Let's just pause right there. Mm-hmm. They have the option. Has the Attorney General's office been contacted by the state auditor's office regarding this provision in connection with the Brickman versus OAG matter?
Yes.
And what's your understanding of that contact from the state auditor's office regarding this statutory audit?
We were made aware of the existence of the statute, and they just wanted to bring it to our attention in light of the settlement road that we were on to make sure that we were aware of this requirement.
The audit's coming.
That's right.
And under this statutory audit, who would have received the state auditor's report?
The Legislative Budget Board and the Legislative Audit Committee, and the governing board of the chief executive officer of the entity involved.
What would that report contain pursuant to the terms of the statute?
The SAO's report would include recommendation on changes that would be necessary to correct the problems that gave rise to the whistleblower suit.
Mr. Arroyo, could you pull up the text of Article 8, please? If I'm understanding your testimony correctly, the OAG's been notified of the statutory audit by the state auditor's office, and those findings and recommendations will be given to the legislature under the terms of the statute, correct?
That's right.
Are audits and cover-ups the same thing?
I'm sorry, could you repeat that?
Is an audit the same thing as a cover-up?
Did you say a cover-up?
A cover-up.
No, it is not. It's kind of the opposite.
If someone's trying to, I don't know, conceal their wrongful acts, should they subject themselves to an audit, in your opinion, as general counsel of the Attorney General's office?
No.
Do you know whether the state auditor's office likes to conceal facts when it conducts an audit?
I do not believe that is the way they are wired.
I don't believe so either. And of course, we talked earlier, your testimony is that the allegations underlying the facts at issue in this impeachment have been reported since they happened. That's your understanding.
Correct.
You've seen reports in the media frequently about the goings on at the Attorney General's office.
That's right.
Texas Tribune seems to have a story every other day about the Attorney General's office, don't they?
There is a lot of coverage.
Do you have any personal knowledge of Ken Paxton ever forming an agreement with Nate Paul and accepting a bribe?
I have no personal knowledge of that.
And do you have personal knowledge of anything to do with Laura Olson?
I do not.
Okay. Do you have any personal knowledge of any vast criminal conspiracies involving misuse of OAG resources?
I have no such knowledge.
If there were such a conspiracy, would you still be working at the Attorney General's office?
No, I would not. I accepted promotion in this agency at a very critical time, and I assured myself and assured my wife if there were ever anything that I saw that were illegal or unethical, I would step away. And I'm still here. I'm proud of the work we do. I'm proud to serve General Paxton. I'm proud to be part of this agency.
Thank you, Austin. Pass the witness.
Ms. Epley, your witness.
Thank you, Mr. President. Hi, Mr. Kinghorn.
Good afternoon.
Have you and I spoken before?
We are old friends now.
That's right. Is it fair to say that you have been my contact to get documents from the Office of the Attorney General?
That's right.
And that our first conversation went well, but subsequent ones got a little chillier?
That's fair.
Now, we played respectfully with one another, right? No one was rude?
That's right.
Okay. Is it also accurate, though, that right after I would have private conversations with you as an officer of the Office of the Attorney General, particular details of our conversation would show up in Ken Paxton's filings?
Objection, Your Honor. Relevance, hearsay, has nothing to do with these proceedings.
Sustained.
Mr. President, I don't know that I've ever seen a lawyer open up a bigger door in regards to the credibility and bias of a particular witness, and I would ask for a little latitude.
Your Honor, this has nothing to do with credibility and bias. She's asking about litigation discovery. That has nothing to do with
I
this.
sustain the objection. Try your question a different way.
Did you receive pressure from Chris Hilton or Judge Stone to provide you information in regards to our conversations?
Not at all, and I can answer your question more pointedly.
I'm certain that he will do that, so I don't want to be rude, but I want to make sure we move forward. Did you receive pressure in coming without a conversation?
Not at all.
Did you receive directives in regards to what position you should take?
None.
So the fact that you and I would have a conversation and it would show up in their filing the next day is completely and totally made up?
Objection, Your Honor. This is totally improper. All parties, all witnesses were free to speak to both sides. That was in the Senate rules that were adopted. And it is only fair that people producing discovery talk to both sides. They certainly talked to people we were talking to. We talked to people they were talking to. That's how the entire litigation of this impeachment has gone. This is completely improper. Nothing improper happened here. And she's not only attacking the witness's character, but my character and my colleague's character. This is completely improper.
Sustained.
To clarify, then, maybe it was the subjective use of a word. As opposed to pressure, did you receive incoming communications that inquired about our conversations?
Objection, Your Honor. Same objection, and this is hearsay.
Sustained.
Okay. You talked some about MIDI, is that correct?
About you?
About MIDI, sorry,
Sorry.
M-I-T-T-E.
MIDI, yes.
Yes, sir. You were not directly involved in that litigation?
I was not.
So mostly what you offered for us was the use of the EAM or people's signatures to validate a contract or an action, correct?
Objection, Your Honor, mischaracterizes testimony. His testimony speaks for itself.
Sustained.
What is the purpose of the EAM?
The purpose of an EAM is to solicit and attain executive approval of an action that's being proposed to be taken or an engagement that's being proposed within the agency.
Thank you, Mr. Kinghorn. And when you personally sign an EAM, are you signing to say, I believe this is a good idea, we should proceed? Or are you signing to confer, as general counsel, there is legal authority?
You're asking about me personally?
Yes, sir.
And I would be signing generally as to legal authority.
Okay, so when Mr. Hilton asked you and you said you were giving approval, it means consistent with your job, that's an available option that we can justify, not this is my idea, I suggest we do it.
Objection, misstates testimony.
He can answer, Your Honor, if it's within his
Overruled.
knowledge. Thank you.
I think that everyone's, depending on their role, their reasonings for going into their signatures a little different. For my role as general counsel, I'm primarily focused on whether the agency has the legal authority to take the action proposed.
And to draw an analogy then, Ryan Vassar, for example, signing Brandon Kamek's contract is approval that it's a legal justified position, not that it's the right one.
Objection, Your Honor, assumes facts not in evidence with this witness.
Sustained.
But your approval is about legal authority, yes or no?
Yes.
I'm going to turn your attention for a moment to the PIA. Are you aware of incoming public information requests as to Ken Paxton's email, Signal, or Proton?
Typically, no. If a PIA request you're referring to is directed exclusively toward the Attorney General, that's probably not a request that would come across my desk.
I think I want to be more specific. Are you personally aware of any PIA requests ever for the text messages, Signal account, or Proton of Ken Paxton?
Objection, Your Honor, relevance.
Overruled.
There's been a great number of PIC requests concerning the Attorney General's personal communication devices. I don't remember with specificity as to the specific types of communication you're referring to.
So you're telling the Senate you do not know if a PIA has ever been requested for his texts?
If you phrase it that way, then yes, I am aware that there have been PIA requests for his text.
Are you aware of PIA requests for his Proton email?
I'm not personally aware of them, or at least do not recollect.
Are you personally aware of PIA requests for his Signal?
I'm not personally aware or don't recollect at this point.
Are you personally aware that he has those accounts?
Again, objection, Your Honor, to the relevance of this. It has nothing to do with anything this witness has testified about. It has nothing to do with anything in his personal knowledge, and nothing to do with any of the articles of impeachment.
Overruled.
I do not have any personal knowledge on the use of a Signal account. In terms of, as I have reviewed the documents in terms of producing to you through subpoena requests, I have seen that there was a Proton email account that wasn't included, I believe.
Are you familiar with the fact that either the Proton or the Signal was set up by Office of the Attorney General IT staff?
I am not familiar with that.
Do you think that you should be if it's true?
Not necessarily.
Okay. Are you aware of the fact, either through a PIA request or the subpoena authority of this Senate, we were not provided any documentation related to Signal or to Proton email for business conducted on behalf of the state of Texas by Ken Paxton?
Objection, Your Honor, lacks foundation, lacks personal knowledge. The witness has testified that this is not within his scope and that he doesn't know anything about any of these. This is an argumentative question with no foundation.
Sustained.
Did you personally respond to our discovery requests?
Yes, I did.
Did you personally have a conversation with me about Proton email?
Objection, Your Honor. Hearsay.
I don't know what to say to that, Your Honor. We're both here.
I'm going to overrule. You can answer the question.
Thank you.
Can you restate the question for me? I'm sorry.
Did you personally have a conversation with me about Ken Paxton's Proton email?
I do remember that conversation, yes.
Do you remember telling me that you knew it existed, but couldn't provide me any of those documents?
I did not say that.
You didn't tell me that you knew that there was a Proton email account, but you didn't know anything about it.
Objection, Your Honor. Asked and answered. She's attempting to impeach the witness with a conversation that she thinks she recollects. This is improper.
I'm certain I recollect it, if that helps.
Overruled. You did ask, he did answer, but overruled.
Okay, so let's try this one last time. Will you tell the ladies and gentlemen of the Senate if you provided us any Proton or Signal documentation for Ken Paxton?
Sorry, can you ask it just a little bit more slowly, just the echoes?
That's fair. I speak quickly. Will you tell the ladies and gentlemen of the Senate whether you did or did not provide us any document in regards to Ken Paxton's Proton or Signal account?
We did not provide any documents related to a Proton or Signal account.
At one point during the questioning, I think what you had said was the Office of the Attorney General is Ken Paxton's law firm. Did I get that right?
Objection, misstates prior testimony.
It was in court today and a moment ago on the subject of Gross.
Overruled.
Thank you.
I've been analogizing, but yes, I did say that.
But of course, that kind of brings me to my next point. As a prosecutor, your job is to zealously advocate for your job is to seek a true and fair, I've forgotten my oath. As a defense attorney, your job is to zealously advocate. But as a civil attorney who works on behalf of the Office of the Attorney General, what is your oath? What are you supposed to do? What's the most important part of being a lawyer for the state of Texas?
Objection, Your Honor. Compound question.
Overruled.
I would say the most important part of my job as a public servant is to faithfully serve my principal and the people of Texas.
Do you believe your principal and the people of Texas to be different? Who do you think your client is, Mr. Kinghorn?
Who is my what?
Who is your client?
My client?
Yes.
Is the Attorney General.
Would you believe me if I told you that when you work for the Office of the Attorney General, you work under his authority and for him, but your client is and only ever is the state of Texas?
Objection, Your Honor. Argumentative, contains a legal conclusion.
Sustained.
Do you believe me when I say that, or do you agree with it now as you sit here?
Objection, Your Honor. Same.
Yeah, same question. Sustained.
You were asked questions about Brandon Kamek, and you relayed a conversation in which he'd called to find out about payment. Do you recall that?
I do.
And can you tell us what month and year that was?
Not with any greater specificity than what I indicated earlier.
I didn't hear you, so would you tell me again?
Sure. I believe it was after I was promoted general counsel, which would have been sometime during the month of November. But it wasn't necessarily during November. It could have been December. I don't remember exactly when it happened.
Okay. So Ryan Vassar was part of bringing you into the Office of the Attorney General, is that correct?
He was.
And Ryan Vassar was a friend of yours, correct?
Yes.
And is it fair to say that you liked and respected Ryan Vassar?
Yes.
And when he was summarily dismissed from the Office of the Attorney General, you rose to his position somewhere around November, correct?
Objection, Your Honor. Argumentative and assumes facts not in evidence before this witness. Moreover, I don't know what this line of questioning is intended to do other than improperly bolster the character of some witness who's not here. The door has not been open to that, so that aspect of this questioning is also improper.
Overruled.
I'm sorry, could you give me the question again?
Were you promoted after Ryan Vassar was fired?
Eventually,
Yes or no?
yes.
Thank you. And it was after that you had a conversation with Brandon Kamek, and Brandon Kamek is asking your office about payment because despite the fact that he's been employed since September, he's never been paid. Is that right?
That's right.
And as of November, there was no contract in place, right?
There was a valid contract.
Then why was he never paid?
At one time. By the time Mr. Kamek reached out, I believe the contract had been closed at that time, just trying to be specific.
So what I'm asking you is, there's a secret, private contract signed only by Ken Paxton, not kept in the office of the Attorney General at some point in this storyline, correct?
Objection, Your Honor. Argumentative, assumes facts not in evidence before this witness.
Sustained.
I don't know how else to do that. The defense's entire position is that Ken Paxton signed a contract with Brandon Kamek, correct?
Objection. This witness has been subject to the rule and doesn't necessarily, doesn't speak for the defense. It's the same question. It's argumentative. It's a sidebar. You've sustained the objection.
If I may, he was questioned at length in regards to the OAG report. Any person who's read it once or skimmed through knows that this is their position. It's not a violation of the rule. It's a question he opened.
Objection, argumentative, and lacks foundation. She hasn't laid that he knows anything about that aspect of the OAG report, and if she wants to ask that question, she can do it, but she has to lay the foundation for it and do it properly.
I'm happy to do that.
Dane, go ahead.
Did you read the Office of the Attorney General report?
I have read it, yes.
Okay, so on page 5, it reads, position taken by the Attorney General in this litigation was adverse to Nate Paul and in support of higher settlement amount to be paid by Nate Paul. Do you recall that being their position?
Objection, Your Honor. If she's reading from a document, I don't understand what it is, and I don't have it.
He's testified that he's read the Office of the Attorney General report.
I didn't understand.
He's been questioned in regards to its veracity. I intend to take him through a list of false and misleading statements to get his position and then challenge him with the testimony of the whistleblowers as allowed by the rules.
Objection overruled.
In regards to the Mitty Foundation, on page 5, it says the position taken by the Attorney General in this litigation was adverse to Nate Paul. You understand that's his being Ken Paxton's position, correct?
Objection, Your Honor. There's been no testimony about Ken Paxton's position, and there's no, are we talking about the report or are we talking about Ken Paxton? I'm still confused as to what we're doing here.
Sustained.
Is the Office of the Attorney General report in question published on the AG's website?
I'm sorry, say that again.
Is the Office of the Attorney General report published on the AG website?
Yes, it is.
And do you have to have either title status, meaning Ken Paxton, or the first assistant in order to publish it?
Yes, that's a fair statement.
And therefore, every statement put onto that website is adopted and made on behalf of Ken Paxton, correct?
I believe that the report is issued by the Office of the Attorney General. Whether that extrapolates to a legal position that Ken Paxton holds pursuant to this proceeding, I'm not going to go there.
So as an officer of the court and a government agent, you're not going to honestly say that anything published on the Office of the Attorney General website is the responsibility of Ken Paxton and something he should be held accountable for? That's your position?
Objection, Your Honor. Argumentative. She's demanding that this witness make a legal conclusion that he's justified, that he's just testified that he cannot make.
He is the general, thank you. Is your position that he cannot be held accountable for what he posts on the website?
My position is that I can't speak to the Attorney General's legal positions.
Isn't that your entire job duty?
Objection, Your Honor.
Let him answer. Let him finish his answer.
Thank you.
No, it is not. My job is to provide advice and counsel to my client, the Attorney General of Texas.
Okay. So if you had to choose between the state of Texas interest and Attorney General's interests, whose do you choose?
I do not see them in conflict.
Okay. Then back to this point. Do you or do you not, as attorney for Ken Paxton, think that he is held accountable for the items that he posts on his website?
I don't know what you mean by held accountable. That's a very vague question.
I'll help. Are you familiar with the Texas Rules of Evidence?
Somewhat. I am general counsel, not a litigator.
Do you understand what an admission by adoption is? Or an admission because it's made by a representative? Or an admission because it's made by an employee?
I'm aware of those rules.
Do you believe that those things would apply in appropriate context to Ken Paxton?
That's not something that I've researched specific to this proceeding. I don't have an answer for you on that.
I think we're all clear on you not wanting to answer this question, so I'll move along. I'm going to give you a series of statements then, and I would like for you and I to discuss them. This investigation revealed the OAG's intervention worked to the foundation's advantage on mediation. If I was telling you, or if that statement's about Mitty, and you have Ryan Bangert, Josh Godby, Darren McCarty, and Ray Chester all disagreeing with this statement, would even them disagreeing change your opinion as to it being valid?
Objection, Your Honor, assumes facts not in evidence before this witness as to those other folks' positions. I don't have an objection to her questioning the witness about a document that I believe is in evidence, but I think in fairness, he should be provided with a copy of it.
Sustained.
So earlier when Mr. Hilton asked you if you believed in the OAG report, you're not actually saying anything in it is true or not true, or that any of us should really entertain your opinion on it, right?
Objection, argumentative, misstates testimony.
Overruled.
Can you restate the question?
Your opinion on the Office of the Attorney General report being truthful is irrelevant to this proceeding because you will not address the statements within it. Is that accurate?
I don't agree with the question as you phrased it.
Okay. Then let's talk about the foreclosure letter. You went into great detail in regards to the distinctions. You relied on 418. Is it accurate to say that applies to mayors and local subdivisions, but not Senator Hughes?
That's correct.
And so Senator Hughes's authority or name wouldn't be necessary if that was the basis of that letter, correct?
I do not believe it was necessary. That's correct.
That's a different question. If the Attorney General was relying on 418, Senator Hughes's approval would not be necessary, correct?
If I understand yes, that's correct.
In regards to 402.042, that you do need an official requester for, correct?
That's right.
And if it was an informal guidance, then no requester is needed at all, correct?
That would be my position, personally.
So in regards to items 1 and 2, you wouldn't need to involve Senator Hughes at all, let alone use his name to put forth an opinion that he certainly would never have approved of, right?
Objection, assumes facts not in evidence. Moreover, she's stating a juror's opinion without following the rules.
Sustained.
Okay, last, in regards to your credibility and the Attorney General's reliance on you, is it fair to say that you represented him in a bar grievance relying on in a government filing or a court filing? And you took the position that the Attorney General was not subject to the bar rules or the state Texas ethics rules?
Objection, Your Honor, assumes facts not in evidence.
I'm asking him, he's on the stand, it was his position.
And you're characterizing that grievance and that litigation. You're mischaracterizing it. You haven't established that any of those things are true with this witness.
That's the purpose of the questioning.
Overruled.
Did you or did you not take the position that the Attorney General of the state of Texas is not beholden to state bar ethics rules?
Objection, relevance. That doesn't have anything to do with an article of impeachment.
Overruled.
Ms. Epley, I'm not sure which, can you be more specific about what complaint you're referring to? I don't have recollection when I sit here as to specific.
Does it feel appropriate to you that you would ever, for any reason, for any purpose, indicate that the Attorney General of the state of Texas was not beholden to bar ethics rules?
I don't think that's what we said at any point.
Pass the witness.
Mr. Kinghorn, do you know if any proton mail or signal documents that would be responsive to their subpoena exist?
I do not.
Did you conduct a diligent search for those documents on behalf of the Office of the Attorney General?
I conducted a diligent search of all documents that we had in our custody and control.
Do you have an obligation to produce documents that don't exist and that aren't in your possession, custody, or control?
I do not.
I have 1 moment, Your Honor. Pass the witness, Your Honor.
Ms. Epley, are you coming back?
No, I have no further questions for Mr. Kinghorn. Thank you.
May he be excused.
May we approach on a quick housekeeping matter? It's just the admission of some records I left at the podium, frankly.
May I excuse the witness? Yes.
That's fine with us, Your Honor.